Welcome to Trial and Medical Error, where we bridge the gap between medicine and law and unlock groundbreaking trial techniques. Join hosts Brendan Lupetin and Unatin as they share novel insights and strategies to help you confidently tackle the most complicated cases. Produced and powered by LawPods.
On this episode of Trial and Medical Error, I interview Ryan McKeen, the founder and CEO of Connecticut trial firm. Ryan is an author of multiple personal injury books, including one of my favorites, Tiger Tactics. Ryan mentors lawyers on how to be better firm owners through the Lawyerist and prides himself on the charitable work that he and his firm does. On top of all of this, Ryan is a terrific trial lawyer and talks about the ingredients that led to a recent $100 million jury verdict that he and his partner obtained. Ryan explains the role focus groups played in the case, the importance of scripting your trial, and a unique approach to suggesting a number to the jury that I don't think you'll want to miss. So without further ado, here's Ryan McKeen. Ryan, so thanks again for jumping on this podcast with me. You have so many irons in the fire and so many things going on. I really appreciate you taking the time to talk with me today. So a lot of people, well, that's assuming there's a lot of people that listen to this podcast, but of those who are listening, a lot of them know you in one realm or another that you're involved in. But could you just give us a little background about yourself, where you are from and sort of how did you get to where you are today?
Yeah, Brendan, thank you so much for having me on. Yeah, I'm from Enfield, Connecticut, so I've lived almost all my life in Hartford County, and I grew up, I was the first person in my family to go to college, to go to a four-year school, as my mom will remind me. She did get her associate's degree, which is awesome, but I was the first person to go to college in my family, cousins, brothers, anybody in my sort of lineage, and went to college, went to law school, went almost straight through. I worked at Enterprise Rent-A-Car sort of in between or during law school, came out, and really all I ever wanted to do was help people as a lawyer. Like that was why I went to law school more than anything. So I got a good job working in a general practice firm, the kind of firms that are dying or not existing anymore, where they're the local lawyer. So people come to them with their problems, whether they need a will, a divorce, they're in a car accident, they're buying or selling a house, they need to evict a tenant, whatever that is. And I got a lot of experience handling all sorts of matters, really. But what I was drawn to was really the personal injury work. And so I was an associate there for about 6.5 years. And this was like 2012, early 2012. I really started thinking about the future. And I was like, look, you have all this cloud-based technology coming online. And look, life has been good for this firm. They've been in business for 60 years. The partners have done well for themselves. But what is the next, my career is going to be longer than the next 10 years. Like, what does the next 30 look like? And so that's when I went out. I went on my own in 2012 and started adopting, using things like Dropbox, for example. And I went into business with a friend. That didn't work out, as often doesn't work out. And then so a year later, we had split. I was a solo. And then in 2016, I founded Connecticut Trial Firm with my partner, Andrew Garza, which at the time was sort of an expense sharing arrangement. And by 2018, we had merged everything and decided to really focus on trial work or doing personal injury.
So let me ask you, you have obviously made amazing inroads into an incredibly competitive market of personal injury law. Can you share with me, I don't know, what your thinking was about how you went about marketing, getting cases, and then, what's the structure of your firm? Are you higher volume, but then you kind of pick, bigger cases out? I mean, how is it all set up and how did you get there from a marketing perspective?
Okay. From a marketing perspective, really what happened is my sort of general practice led me to I just cared about my clients. Like I just did good work for them. And, put their interests first, did those things. And so what happened is I agreed to take a case pro bono from a probate court for a incredibly wonderful woman who was getting screwed, for lack of a better term, on this ERISA issue from her ex-husband or her husband who was then deceased. And I took it and I helped her navigate this and ultimately got her the money she was entitled to under his retirement account. And in the process, what happened is tragically, her daughter was killed in a car accident. She was crossing the road. She gets struck by one car and then run over by another. And that really begins my sort of foray into serious personal injury work. And I had done car accidents. I had dog bites, the sort of run-of-the-mill stuff. But this was a heavy-duty wrongful death, involved a case against police. And I said, the client trusted me. It's from an immigrant community. And I said, this is what I want to do. Like, I'm going to go for this. So I started doing things like reading David Ball and reading Don Keenan because it was a question of like, am I going to keep this or I'm going to refer it out? And I knew I couldn't sell this client short. So I said, I'm going to keep it and I'm going to do the work. And if I feel like I can't or it's too hard, I will refer out. So that was my first sort of wrongful death case. And then what happened is I sort of benefited from sort of a confluence of I would say two things. One of which was my firm had a terrible website, completely awful. And I went to them and I said, hey, can I start a blog? And this was like in 2007. And they said, well, how much does it cost? I'm like, I can get a domain and a WordPress license for $100. They said, oh, go ahead. Start a blog. Well, what would you do on a blog? I'm like, oh, I just write about law stuff. And so I started writing up a blog and I started building sort of just a following organically. I would like to think that my LinkedIn page right now is sort of a continuation of that blog, but I'd write about general sort of legal issues, really written for the public in a way that they could understand. That caught on. I would also share it on social media, and it was a time where Facebook was coming online in like 08, 09, 10, and outbound links were still viable on Facebook. And what happened tragically is two things happened. One of which is I became sort of famous in Connecticut because I questioned the credentials of one of the state's top politicians who was running for attorney general. And I was actually correct that she wasn't qualified. People thought I was crazy, but the Supreme Court ruled that I was correct. And so that brought me all sorts of notoriety. And then tragically, somebody I went to high school with, their father-in-law was killed in a motorcycle accident. And it was a commercial case. And that case resulted in a $2.25 million settlement, which was sort of like my first, I would say, really big settlement. And the police case is confidential, but I mean, it was also significant, but this was even more so. And, but I started going to all the Keenan Trial Institute stuff. I started doing all these things. I just really developed a real interest. And so I took some of that money and I put it onto Avvo at the time. And Avvo was giving me like 4 or 5 good personal injury cases a month almost at the time for very little money now. I wish I probably put more on it. And so that's sort of how my practice at that time got started from personal injury. And the other flip of all of this is going on, just referrals. I would talk to lawyers. They would send me their cases that they didn't want to do. Some PI lawyers would send smaller cases that they didn't want. And I was like, I don't care. This is the work I want to do. I don't want to be doing the family law that I am doing to pay the bills and whatnot.
So because this is generally I'm a very trial-focused, trial strategy type podcast, can you tell me about sort of your biggest influences when you're picking up your first big personal injury cases, over the years now looking back, what would you say were your biggest influences as far as like how you try cases, how you think about trying cases and so forth?
I mean, really, there's one. It's Don Keenan for sure. I think, his trial teachings and his insights are great, and they resonate with me. A lot of it, we talk about reptile, and a lot of that gets overblown because a lot of it is really good fundamentals of do this, then do this, and then do that, and here's why you do it, and here's what you don't do. And, oh, by the way, go do focus groups because that's incredibly valuable. So I'd say, Don Keenan. But, I mean, look, you start reading all these trial books, right? Read a bunch of them, and they all sort of drink from the same well. So you've got your Rick Friedmans, your Mark Mendel's. I mean, these are fantastic trial lawyers to go read. So, yeah, I mean, all of those sort of books become canon in my office. for reading, Jerry Spence. And so just taking little bits from all of them and, adopting it to whatever the problem was in front of me was very valuable.
I think that's a good segue into your, truly gigantic, verdict that you obtained, which was one of the many reasons I wanted to talk to you about, just in general, your thoughts and so forth. And you already mentioned focus groups, so I really want to get into that because I'm a huge proponent of focus groups, and I too am a Keenan, Ball, Disciple, Edge, Reptile, and every other book from Trial Guides that's ever been published as well. So can you tell us about, give us a 30-foot summary of this case that led to this just unheard of verdict?
Yeah. So, the case itself is pretty simple. Our client, Mikey Cruz, works in Rexel, which is a warehouse. Rexel is a large multinational company, and basically you have to think of them almost like a Home Depot for electricians that sells light bulbs and associated electrical products. One of their biggest clients, or is I guess maybe the client's the other way. One of their biggest distributors is Philips North America. They make all the light bulbs, and so what happens is, this is one of these that just lends itself to whatever these Mark Mandel profits over people for my trial geeks out there, right? So Philips is actually at the time experiencing 2017 some economic headwind, so to speak. They do a stock buyback, but one of the things that really changes the game from them are these TLED light bulbs. And so this is at the time where there's a lot of like retrofitting of fixtures for energy efficiency, right? And these light bulbs don't need essentially another component. You can put them into an existing socket and you will have achieved energy efficiency as a result of doing this at a lower cost without an electrician, much easier. So these TLED bulbs in the summer of 2017 are very, very in demand. And so Rexel orders a bunch of TLED bulbs from Philips North America. And because they have a show at Mohegan Sun, which is a casino in Connecticut, where they invite a whole bunch of electricians, but it's basically Rexel's equivalent of Black Friday. So, right, so we've got money. And so what happens is Philips gets these shipments in from China, and they get shipped in by rail, get brought to a warehouse in Mountaintop, Pennsylvania. And the way things are shipped is that when things are shipped from China, they're not palletized because the wood over there is bad. It would take up space in shipping containers. There could be termites and bugs or whatever. So for a variety of reasons, they don't put things in shipping containers. And so what they use are these things called slip sheets, of all things you can call them. And they use clamp trucks. So a clamp truck you have to think of as like hugging the pallet to move the load, as opposed to what we use, what's used primarily in the U.S., which are forklifts, which go under a pallet. And the other reason for this is economically, reach trucks are far more expensive than forklifts. So they do this. So these pallet of light bulbs, or these light bulbs come in, they're on a slip sheet, they're not on a pallet. What Philips has to do is they have to take the light bulbs and they have to put them, there's 1,300 pounds, they're all banded together with plastic, and there's a slip sheet underneath. They have to put them on the pallet, and then they have to what they call unitize it. So they have to make it all one load, which is, they can do it one of two ways. They can do banded, or they can do shrink wrap that wraps it all around so it's one unit. So it can't move separately in shipment. It's actually a federal trucking regulation because you don't want load shifting in transit, right? So what happens is they go and they just put these light bulbs on a pallet and off it goes, right? It saves them, our expert testifies, $5 in 5 minutes. The light bulbs go to Rexel. I think it's on a Thursday. They go up on a top shelf of the warehouse, which is fine. Like, there's no warehouse. OSHA finds actually nothing on Rexel that they did anything wrong. They go up on the top rack. And as we talk about this event at Mohegan Sun, Rexel is trying to staff up their event for Mohegan Sun. And so what they do is they use a temp company called Spec personnel. Spec provides a guy named John Paul Paez, and Spec ignores all of the qualifications. Like they have to do a drug test, they have to do this, they have to do these different things. Essentially, for the sake of speed, they don't do that. They furnish a guy named John Paul Paez, and John Paul goes and lifts a load on an adjacent rack. It catches, it shifts, the load falls, the pallet stays up, okay? The lamps fall, light bulbs fall, they paralyze Mikey Cruz on the adjacent aisle. And after that, Paez goes and they take him for a drug test per protocol, and they find a significant amount of cocaine in his system.
Oh, wow.
So that's the case.
What was your client doing there at the time?
My client worked at Rexel, and he was like a front desk worker where an electrician would come in and say, hey, I need 10 LEDs, right? I need 10 TLEDs. Mikey would go in the back and go through the shelves and get 10 TLEDs and bring them back to the front counter. So he was picking an order at the time he was paralyzed.
Who were the target defendants and what were your main theories? And more, what did the main theories boil down to at trial?
The target defendants always were Phillips Signify because it's a failure analysis, and the first person who could have prevented this was Phillips Signify. Our expert testified that had they followed the rules, the load would not have fallen, right? So Phillips Signify is always the primary target, and just typical failure analysis. Ask yourself, in any case where you've got complicated causation, who was in the first position to have stopped it, right? Everybody downstream should be able to sort of rely on the first person doing their job. Obvious second target was spec personnel for negligent hiring, furnishing John Paul Paez, and John Paul Paez was also a defendant in this. On the morning of opening statements, as is the case, oftentimes, we also had a very lesser defendant, the owner of the racking system in the warehouse. They ended up settling out for $2 million before trial, and then Spec and Paez settled out for $6 million the morning we gave openings. So the only defendant left was Phillips Signify.
Had Phillips offered any money?
A joke. They had offered $1.5 million.
Just because they felt they were so far removed that you weren't going to be able to prove your case, basically?
If I'm being kind, yes. Yes.
And were you concerned at all, and did they attempt to defend, at least in part, on using the empty chair? You settled out with these two other defendants and trying to cast blame off on everybody else but them.
Yeah, that's a really great question. And it's a question that we wrestled with internally the most. Because yes, we wanted to keep everybody in. There's no empty chair. There's no this, there's no that. And what we basically learned is that when we really put the focus on Phillips, the focus groups were like, Phillips did this, right? They're like, Spec and whatever. By the way, the drug stuff never came in. Our toxicologist got precluded. If I'm being kind to the judge, essentially, if you're going to be high on cocaine or high on a drug when you are operating heavy equipment, cocaine is the one that least impairs you.
Oh, wow. So it was okay because it was cocaine.
It's a stimulant, right? I think our talk should have come in. It was shocking that he didn't, but it's one of these things when you try cases, that happens. A judge rules your toxicologist, who's from Harvard, who's never been precluded before, cannot come in. But so this is the sort of case we're left with. And, you're left with, at the end of the day, first of all, we were able to secure enough money for Mikey Cruz to change his life, which is
with the $8 million alone, right?
The biggest thing. Mikey never dreamed of owning a house, was put through hell throughout this whole process, and is now able to support himself and not have to worry about money, which is the goal of litigation, period. So when we were able to get that, we knew that the jury would blame some onto Paez and Spec, but we didn't think it was that much because Paez was somewhat sympathetic. Like he was sort of like a person who struggles in life, not the smartest,
sure,
not the sharpest knife in the drawer, and we didn't want him as the face of this. We wanted Phillips. And, one of the things that my partner Andrew Garza did, which was brilliant, is we never called John Paul Pius in our case. We just were like, this is not about him. But one of the things that had happened was the defense called Pius out of order, like it was one of these scheduling things. And our expert testifies, and our expert says, look, like, had this been wrapped, they wouldn't have done it. And Andrew took it and did one of these Keenan judo things and said, I really wish John Paul Pius was here to hear that. You saw him. He's experiencing a tremendous amount of guilt about this, right? And so we felt pretty good that, the jury was going to come back about where they did. It could have been 80-20, but it came back 90-10 on Phillips.
And let me break down a few things there. So first, when you said they called him out of order, meaning they called him during your case in chief because of scheduling?
Yeah, I think so. My memory's a little hazy of it, but I think there was some scheduling conflict that it was one of these things. It was it was tried over 11 different days, and the judge was a stickler on like filling every minute, and coordinating a bunch was hard. But I think it was out of order.
So did you have to, did you take a lot of stuff on video testimonies that you could kind of plug and play throughout, or was it more live witnesses throughout?
Almost all live witnesses.
Oh, wow.
When you're the only person we had on video was the client's treating doctor, the physiatrist, who won't testify live. Like, he just is like, I will never come to court. I'm too busy. And he, in fact, is like world renowned and incredibly busy. But, we felt it so critical, just given the case and the value and the issues involved, that the witnesses be live, that we made sure that they were all live.
And so talk to me about the focus groups. How many focus groups did you do beforehand and lead up to this? And how did you run them? Did you guys do them yourselves? Did you farm them out? A combination?
I think we ended up doing 10 of them. And we did them all in-house. We did them, in fact, all on Zoom. So that was incredibly useful. And, and also having the recordings, being able to do summaries of those recordings, being able to do demographic research on who was favorable and who was not. All of that was just really, really, I think, the most important work of the case. We did our $100 million day in Boston, where we taught all of this. And, as we were going through the planning process for the conference, it was like this whole thing could just be on focus groups. Like, we could not do anything else. And like, that's where all the meat, all the value is. I mean, really.
Can you, I know it's unfair in a limited episode of a podcast, but can you give us a sense? I've talked a lot about podcasts on earlier episodes because, like I said, my partner and I are big proponents of them. What's the biggest advice you could give to somebody who either hasn't done focus groups or is not particularly experienced doing them, with how to best utilize them in their cases?
One, if you haven't done focus groups, you're not doing your job. That I'm going to be straight with you out. Look, if it's a rear-end car accident case and whatever, there's a total possible verdict of $12,000. I get it. But if you're doing the real anything that's worth doing, in our opinion, in our firm, anything that's worth trying, like, you need to be doing a focus group to do your job. The second thing I would say is, like, look, go and learn. Like, go to Keenan Trial Institute. I know Andrew Finkelstein's doing something with like trial college. I can't keep track.
TLU and Trial College and all these different entities.
Go and learn, or AAJ does something on focus groups. Go and learn how to do them. Because a lot of people, the biggest misconception, Brendan, is that these are mock trials or something. We never, ever, ever touch a mock trial. It's more like, we do things like we put a picture of our expert and his credentials versus the picture of their expert and his credentials. And we're like, tell us about this. What do you think? What questions would you ask? Who would you think would be the better expert? Why? And you just sort of tell me what you see in this image. I'm going to play you a clip of this witness. What did they say? What did you learn? And then start sort of unpacking, if I said to you, start unpacking like where they're going. If I give you some basic facts on the story, ask why it happened, what they would want to know, what they would ask of the witness, we would do things like, and part of it was like, we had some really, really tough stuff. Like, I knew that being paralyzed was bad. But I never honestly gave it all that much thought. Like, I think like, oh, you can't walk. No, no, no. That's like the least of it. And so we had to go into, like, there was a big loss of consortium claim. We had to go into the sex life of somebody who's paraplegic, where nothing works below the belly button. And so it was like, well, how much, can we go too far? Can we appear to be overreaching or whatnot? So sort of to test those boundaries. And, they're not terribly hard to set up, but they do require some base level training from somebody who knows what they're doing.
So you mentioned you did almost all of your, if not all of the focus groups via Zoom. Was that a product of sort of fallout after the pandemic?
It's a product of a few things. One, it's a product of fallout of the pandemic. The second is we were able to get people who were actually more likely to be jurors when we did them during the day and on Zoom. So somebody could log in from their house. They could be working from home and take a long lunch or something, whatever they were doing. But we actually got more jurors, which sort of like makes sense because, who's driving in and, doing them at night, which was typically when we would have to do them. It sort of limits your, focus group participant pool.
May I assume that before this, or maybe before the pandemic, you guys typically did them in person?
Yep.
And going forward now, will you still do some in person, or will you always do them via Zoom?
All Zoom. And part of the reason why is it's so easy to record these, because it's very difficult to run a focus group and get all of the information that you need or pick up on everything. So the ability to record is incredibly powerful. And the other reason why you want to record it was we did it at mediation, and we played a clip of focus group participants saying a whole bunch of things about the defendants and their various problems in the case, right? Because the defense lawyers did none of them. And so they would say, oh, well, nobody's going to believe this. And we have the clips ready to go. And we were in a hotel because there were just so many parties in this giant conference room. And we played a whole bunch of these clips for the defense. And at the time, Spec was offering no money. They took a no-pay position. The mediator had knocked some heads that day and pulled together a $3 million package, which was a joke. We knew it wasn't going to settle. But then we started getting calls from the other defendants who wanted out. It was, $2 million from Venture. Okay. And then it was like, can you do $3 million against SPAC? And we're like, no, six. And, we ultimately got them there before trial, but the offer started escalating to the point where probably 6 weeks after our mediation, we had a package from various defendants that could have totaled probably $12 million on the table.
Do you feel that obviously I think the initial reaction typically when you show focus group video to defendants is they just knee-jerk reactions to kind of disregard it. I've had, sort of people, oh, well, how do we know these people or what you told them and so forth? Do you think that it is effective eventually, immediately? How does that play out?
Yeah, look, I knew we were in this big conference room at the mediation or at this hotel. And there are adjusters from all over the country, maybe even all over the world. I have no idea who these people were, but it felt like there were 35 people around this like U-shaped conference facility in a suburban Hartford Marriott. Okay. And I knew when they were going to be played during the presentation, and all I was doing was watching the adjusters' faces. And there was some particularly some of it was like, look, they're a deep pocket. They're multi-billion-dollar businesses. They should take care of this guy. And so there was some real fear from some of those people in that room that was palatable on their face. Whether or not they would have got there without it, I don't know. But I can tell you, watching their reactions, there was let's put it this way. They knew that we weren't, they knew we weren't flubbing anything. It was these are the things that you're going to be facing. These are the things a jury's going to be thinking.
I remember, I think but always when Keenan was, touting the importance of focus groups, I think one of the points was, if nothing else, even if they don't believe the data that you're showing them from it, you're nevertheless sending the message that you're preparing for trial by doing focus groups, which in and of itself can raise eyebrows on the defense side.
Defense doesn't like risk, and these people are even more risk sensitive than I think plaintiffs' lawyers by orders of magnitude. And so when you start seeing, and again, like we had 10 focus groups, so we probably had like 70 participants to choose from. And so when we're doing 5-minute or 10, 15-second clips of 7 or 8 or 10 different people on this one issue, well, it becomes very hard for the adjuster to sit there and like just ignore what all of these people are saying to this one point.
Do you so in your focus groups, do you do all sorts, and as far as like, do you do plaintiff and defense clopening, or do you do like the chunking out where you start piece by piece? What do you think next? Ask questions, move on, and so forth. I know you talked about doing specific issue type focus groups.
Yep. So we don't do any of the plaintiff and defense. Keenan teaches it. Keenan teaches, and we believe it, that we've done something similar at one point. But what Keenan is basically says, and I think is right, is that what they're really trying to tell you is who they think is the better focus group lawyer. And so I mean, look, if I could have the defense attorney give it, like, that would be tremendously valuable, right? But if I'm pulling a colleague or another lawyer in our firm into it, they may just like one or the other more. And that's sort of like what it is that they're asking. So I think it runs the risk of being distortive more than useful. And so what we try to do is really sort of like, we try to give them most of our focus groups are here. We're going to give you a little bit of information. Like, okay, here's this thing. It comes in from China. Like, what do you think Phillips should have done? What if we told you the rule was that they had to do it? What kind of training do you think their people should have had? Who do you think is responsible? Like, was it the corporation or was it the dock worker? I mean, like, all of these sorts of things, taking surveys. What do you see in this picture? And sometimes, like, we would take deposition clips as well. We videoed every depo. What do you think about what this person's saying? Are they being truthful? We would do direct examination. We do videos of our clients and of key witnesses. I did damages witnesses, for example. And I would play, like, what do you think of this person? So as we're trying to narrow our damage witnesses, that's what we did. As we got really down to it, we did focus test our opening. So I had my partner Andrew give an opening statement that he was going to give and get feedback on that. But, I think it's one of these things where, at least my belief is, and it comes to, I'm not an original thinker on this, is like, what the defense is doing almost doesn't matter. It is like, you have to know your story, and you've got to present them with like, you got to present a jury with like two different worlds, like pick world A or world B. And so we try very much not to respond to what it is that they're doing, other than to use it against them, which is like, look, and they're all predictable. I mean, the great thing about this work is defense lawyers are never original, right? They just got up there. They tried to point the finger every which way. We told the jury they were going to do it. They did it. And, it looked to the jury like, here's a big company just doesn't want to take responsibility up against a paralyzed guy. I mean, it wasn't hard.
So let me ask you a few things, based off what you talked about. First, it sounds like you go pretty far back in drinking the Keenan Kool-Aid, as I have over the years. Do you remember the time when, not necessarily advocating, but Keenan was suggesting that it's not the end of the world if you were to not so much read verbatim, but to somewhat read your opening, so as to limit your advocacy appearance and opening? I don't know if you remember that they talked about that at some point in time. So my question is, did your partner give the opening, spontaneously without notes, or
Nope.
Or tell me about it.
Absolutely with notes. And I mean, don't get me wrong, like, he knew it, but it was written out verbatim.
Okay.
And this is a really crucial thing. And we did talk to jurors afterwards. Your like your production level when you are trying a case in 2023, 2024, hell, even going forward even more, it has to be smooth and concise and scripted, and like there is no winging it, and there is no wasting their time or rambling. It is like you have very limited window to do what you need to do. You better do it right, because juries will punish you if you're disorganized. They think you're wasting their time. You're unprepared. It's a sign of disrespect. And it's also a sign of, confidence. Like, hey, I'm going to do this thing. I came here before I got to court this morning, and I had this written out. It's important. And I think sort of like, look, where are our examples in society, right? Like, well, I won't, this is maybe a bad one, but, we'll say prior to 2016, like, the president of the United States doesn't come up to a podium and just start babbling. It's scripted. Why is it scripted? Because it's important what they're saying. And I think that that's the general belief amongst jurors.
Well, and so I ask you that because I've wrestled with that. And, I have been fortunate enough to get some decent verdicts, both doing the more, very word for word, focused on my notes, scripted opening. And it's also, I've had success, when I practiced over and over and over again, but didn't really use notes. I mean, obviously I had images, I had a very set presentation. And so I recently went to the TLU in Manhattan a few months ago, and there were some, a couple, top of the food chain trial lawyers around the country, inner circle members, et cetera. And they were just so strident about you cannot use notes in your opening statement. And to me, I felt I don't necessarily agree with that. And so it's interesting to hear that you guys approached that and got. And by the way, Ryan, what was the verdict? It was
100 million, and it was
on the nose.
On the nose, and it was 10% onto spec, so it was 90 million against Phillips Signify.
And by the way, where's that stand on appeal and so forth?
Oh, fun. Yes, there are appellate briefs too. Ultimately, there was a remitter motion. The remitter got granted essentially because the judge says, oh, well, this is the highest verdict in Connecticut, and it's too high. He knocked it down to 50 million, which or thereabouts. Like, I'm being a little bit precise. We'll call it 50 billion for the purposes of this podcast. And our appellate lawyers were like, look, this is a lot of money, and you should accept it, because then it becomes their argument has to be abusive discretion versus ours and retrial. And basically this puts us in a driver's seat. And also it's a ton of money. So we did accept the remitter strategically. And also in Connecticut on appeal, not insignificantly, if we were to appeal the remitter, which is what we would have to do, interest would not run. And so right now interest runs at a rate of $8,000 a day on our verdict, which
it's a nice interest rate.
Yes.
Can't get that anywhere else.
Nope.
So, but I guess coming back full circle, by the way, just out of this world verdict, let me ask you this. When you did the focus groups, Pennsylvania, unfortunately, is one of 3 states, I think, where we cannot ask for a specific amount of non-economic damages. Now, obviously, you had a very large life care plan, I'm assuming. But I presume you were able to ask the jury or suggest to the jury an amount of money they should award?
Yes, we were.
And what did you guys suggest?
Oh, this was, God, we all stand on the shoulders of everybody. And one of the people that we stood on their shoulders of here is Andrew Finkelstein. Just amazing business partner, amazing trial lawyer, and ultimately an incredibly generous human being. So I was actually, we used Andrew's company, Total Trial Solutions, for animations in the trial, which was amazing. By the way, I don't get paid for this, but like, if you're out there looking for animations and things like that, they're amazing. If they're good enough for Andrew Finkelstein, they would be good enough for us. Was our sort of belief. He's very high standards. And so we're doing it. And I was actually out in Vegas at a conference while the defense was putting on their case. There was just there's like a little bit of a window. So I went out to Vegas for 2 days and I saw Andrew. And Andrew said, hey, Ryan, how's the trial going? I said, it's going well. We're going to kick their ass. And I said, he's like, what do you think a verdict's going to be? I said, 100 million. He's like, okay. He's like, you don't know how to ask for 100 million bucks. I was like, nope, I don't. He's like, you and your team are going to call me on Saturday morning, and I'm going to tell you how to ask for 100 million bucks. I said, game, let's go. So we took a call, and Andrew walked us through this closing, which was, I mean, honestly, like, I can send you the transcript, or I can send it to people who are listening if they want it. It is one of the best closings that I have read. I didn't write it. I didn't give it. My partner Andrew did. It was moving, powerful, and to the point. And so what we did during closing was we went through Finkelstein's way of asking for this, which was we threw out, we did this thing about, we did basically like a job board, which is probably familiar out to your listeners. Like, what would I have to pay somebody to go through this, essentially? It's what you're going to have to do. So we framed it for the jury in that way. And I came here and I was thinking about the number this morning, and I thought about $150 million. That's what I thought about asking you. So you put out a larger number, sure, and you say, you know what, but I don't think that would be fair, just, and reasonable. I know Mikey, I know what he's been through, and you know what, there's not any amount of money I'd put on it, but to the extent you're going to have to, I think 150 is too high. 140, also too high. 130, too high. 120, too high. 100 million. I'm not going to ask for that, but you've heard all the evidence, and you can decide what it is. You can go higher or lower. I'm not going to ask you for 100 million. Not going to do it. 90 million. You know what? If you want to give it, I support it. 80 million, 70 million. Those aren't the numbers I'm going to ask you for. I'm going to ask you for $60 million. And then what we did is we said, look, and here's how I got there. If I told you that the person, if this case was just about him being injured and never being able to have sex again, if I came here and asked you for $5 million, none of you would bat an eye. If I told you he could never walk again, and that's all this case was about, 10. And so we kept building up all the harms and losses until we built it up to $60+ million. And we said, look, you're the boss, you're the jury. We empower you to go higher. You think we're asking for too much? It's your call. And so we took that leap, and not to my surprise, the jury came back with $100 million.
Amazing, which is exactly what that prime number you had suggested to them, right?
It was the first number in the 8 or so that we read that we suggested that they should fight for if they think it was reasonable.
Gotcha. And those are your German Shepherds, is it, Ryan?
Yeah,
that,
let me.
You had.
Can I mute? I have an Australian Shepherd and a German Shepherd, which are a lot of fun, but boy, do they not like Amazon people.
Well, I told you they were welcome to join us on the podcast. So let me ask you this. In that, I guess I'm just trying to, why did you have 100 million? And also in Connecticut, is it a single number that they just come up with? Or, here they have to itemize the life care plan per year and all this kind of business. What are the line items for damages in that case?
Line items for damages are really basic. It was a line item for economic damages, a line item for non-economic damages, and a line item for loss of consortium. So they came back with $15 for economic damages. We had put in about $6.5-7 million. Maybe it could have been 8. But, and this is where we got hit on remitter a little bit, which was, we said, look, like, this is what we suggest. It's not like it could be more expensive. It could be less. He could lead us on more. We can't really predict, up to you. So they gave us 15 in that. They gave us, 75 on non-economics.
Okay.
And they gave us 10 on a loss of consortium claim.
What was the life care plan? How much was that? Had that totaled up to?
Oh boy, I really think it's about $6 million.
Okay.
4 to 6. We actually toyed, and I actually don't think it would have mattered much. We actually toyed with not putting it in at all
because of anchoring effect.
Yep. We decided to do it, but it was not a slam dunk for us.
That's a pretty big one not to put in I know, even the circumstances, but that's a pretty high number not to put in.
It's just that we felt that the gravity of the harm was so significant here that truly, and honestly, like if we talk about the job ad and knowing all I know about paralysis, knowing all I know about my client, Mikey Cruz, all I know about what the defendant did and didn't do and why they didn't do it, there is no way that I would trade places with him for $100 million. Like just no way. So like we're in a case where there's essentially like no right number. Our focus groups basically told us there was also like no ceiling on what we could ask for. Like we couldn't offend a focus group if we asked them for $1 billion here. They might not have given it to us, but they wouldn't have been offended. Because when you
that's what I was curious about. Did you specifically test any number, like specific numbers with your focus groups to figure out what the best ask for?
Yes, we did. And look, there's a lot out there in focus groups of, they're not predictive for numbers. They're not this, they're not that. And Sean Claggett and others, and I think we come around to this, are like, well, yeah, if you just give them a blank slate, like you can't rely upon what that is, right? So there were several different ways in which we tested, like, basically one of them was like, hey, look, they're offering $20 million, which was what they disclosed the policy. Like, would you take it, or would you advise him to take it, or would you advise him not to take it? Like a very basic sort of question like that sort of framed it in a different way. And so what we were trying to do was hit them for what we thought was the disclosed policy, which was $20 million. And being what companies are, we hit them, and then they file the disclosure that, oh, there's a $150 million policy.
Of course.
Wonderful. But so it was more testing along those lines. And then there was some basic, like, would I offend you if I asked you for $1 billion? We didn't ask them for $1 billion, but stuff like that. And so what we were confident of was that basically the policy offer, even if they tendered, was too low. Obviously, like, the risk was too high, but we felt confident that we would break through that policy. Like, that's what we felt comfortable. We felt confident in. Whether that was 35 million or 40 million or 60 million, I would say that the higher you go up, there was less degrees of certainty on it.
Did Phillips offer more money as the trial unfolded?
No. We got a call.
Well, thank God, though, in a sense, right?
Oh, I got an email on a Sunday from the defense counsel. He said, Ryan, I'd like to talk with you later today. The excess carrier has a proposal they've asked me to forward to you, and I think it's serious. Would you have a call? I said, all ears, right? Excess carrier, all ears. So we have the call. We have internal calls. So we have internal calls, and we're like, oh God, they're gonna take this away from us. They're gonna tender, or we thought maybe they would do like a high low of 10 low and the high of the policy, or some combination of things. I get a call, and he says, got a proposal. Okay. Low of 2, high of 4.
Oh.
He said, look, I got to take it back to my client, Chris, but I'm not going to waste your time or mine. It's going to be a no. And so it made it very easy. And, this is one of these things where this was actually one of the hardest parts of the case. And when you talk about nuclear verdicts, why they happen, one of the reasons why they happen is early misassessment of the case by counsel. And so what happened is they had misassessed the case like gravely. And the way they had misassessed it was that they basically took a position that this wasn't our package, which was insane to us. Not going to bore your listeners with the reasons why they deluded themselves into thinking it, but suffice it became narrative, and it just became dug in, and they're just trying to go after us because we're a deep pocket and we don't have exposure. And the VP of Phillips Signify, a guy named Michael Manning, sat through trial, and they were like high-fiving throughout the trial. And, he said to me after the jury was out, he didn't say it to me, but he said it to his lawyer loud enough so I could hear it. We have the best risk managers in the world look at this at AIG, and the absolute worst day for us is $6 million. And I was like, you didn't see the same thing I just saw. I'm texting my buddies, we're going to hit him for $100 million. I know we are. And the the fun thing is so the jury goes out and they have to go through these interrogatories, and the interrogatories are all, who's at fault. If they're not at fault, skip ahead and return a defense verdict kind of thing. And so they go through very quickly, maybe within 20 minutes, the liability portion. And the way we know it is they come back with a question, and the question is, can we see the life care plan?
Oh, that's the best question, right?
And so we had known that they've gone all the way through the liability, and these guys just sat there. And I was like, it's crazy to me that they're not getting an offer, because we couldn't understand what they were doing. We didn't. This is why we actually ended up doing 10 focus groups. I wish I could say that it was just like we were so amped up about it, but we were paranoid that we were missing something. Like, why
Sure.
aren't they doing this? And it became apparent to us by having done the focus groups that we were missing nothing. They were missing things. But then we kind of thought, well, maybe what they're doing is just forcing us to go through trial, trying to try it on the cheap. Maybe something happens. Maybe we get scared. Maybe, and then tender. Because if they had come to us and said, here's $20 million, like, look, it's probably,
With what you knew, how do you not take it? Yeah.
I mean, we would have taken it. But that was always a concern. But it was like they never got it. They never got it. And not until they did.
How long was the jury out after that?
The jury got the case probably about like 11, and then they came back and returned a verdict about 4 that afternoon with an hour break for lunch.
And I'm a little more superstitious than you. I'm amazed at your level of confidence as you're waiting for that verdict, that you knew you were going to get a monster verdict.
We had done the focus groups. I had watched the trial. I had read every single book. I know what resonates, what doesn't. I had been there for jury selection. I knew who was on their jury. I knew we had demographically favorable jurors. And, the tech guy was like, they're in a lot of trouble. And so, we had jury watchers as well, who were sitting there taking notes on what the jurors were doing. And I think, look, you never know. But there was a high degree of certainty with me, knowing what I knew, watching this whole thing, the focus groups. Look, you can always be surprised, but I think I probably would have just quit had they done something like returned a defense verdict. I would have just been like, I shouldn't be a lawyer because everything I know about the universe is wrong.
Right. So last couple questions, and we'll get you out of here because I'm already butting up on all the time I said, but there's so much more that I wish I could talk to you about. Do you think that this is a, firm-changing, reputational, life-changing verdict. Do you see it impacting the way that your firm looks at, cases going forward? Like, do you think you'll be more likely to try cases now that you've had such success, or do you think you'll just continue to, the case that need to be tried, the case should settle, et cetera?
Somebody told me, the difference that separates the legends from the mortals in this line of work is the legends try their best cases and the mortals try their worst ones. And we spent a lot of time trying our worst cases, which is probably true of many firms, and understandably so. Trials of giant risk and effort. And, sometimes you try cases because you have to. Right. And so what's happened with us is we have an aggressive focus of being in control. And so we are like, here's what value is on this case based upon our whatever assessment. You are going to pay us, or we are going to try this case. Like that it makes negotiating very, very easy. And look, you leave room because you say, look, if there's some thing that we don't know, like, we can adjust our position. But, as things become clear to us and we know what the value is, you're paying us or you're going to take a verdict. And so what happened is my partner Andrew and then my one of our lawyers, Alexa Mahoney, they took a verdict 3 months later, and this was more in line with most cases. I think that most people have $50,000 car accident case. We're in a car accident case, $50,000 in meds, surgery, nice woman, and ended up returning a verdict of $3.4 million on 50 in meds. And so after that, the defense bar just started paying multiples to us. Like, we would say, you're going to pay us X, and we'd have a call and they go, that's way too much, you're insane. And then 2 weeks later, they call back with the number. So our impetus, our desire to try cases is high. And sort of right now, I think what we're looking to do more is get in and co-counsel and sort of come in at the last minute to try to get some reps on some trials, because it's increasingly hard when they're offering above policy or offering value. I mean, trials risk, no matter how good you think you are, you will lose, and the legends lose. So if you're doing right by your client, like, that's what you need to be doing.
Well, this is awesome, Brian. So we didn't even get to, talk about all the books that you've written, your work with, Lawyerist, which was how my partner Greg got to meet you in the first place. I heard you first through all the Maximum Lawyer stuff. And but for anybody that wants to, either connect with you, contact you, co-counsel with you, come and listen to you speak, can you tell me, what's the best way to get a hold of you, and where are you going to be talking or speaking in the next few months?
Yeah, LinkedIn, friend me, follow me, whatever you do on LinkedIn. I put a lot of content out in LinkedIn. So Ryan McKeen, LinkedIn, Connecticut Trial Firm, you can find me out there. For speaking arrangements, tomorrow I am going up to actually Mass Bar and speaking at their Leadership Academy. But I am, this is going to be no good to your audience, because this will not go on today. But I will be next at National Trial Lawyers down in Miami. I think I'm speaking the Friday, Saturday.
Awesome. When is that?
It's like the 19th through 21st, or it's whatever basically the third week is in January.
And I think you'd made this kind offer earlier, but if I email you, can I get a copy of that closing and maybe be able to share it with people that would be interested?
Absolutely.
I'd love to see what you guys are up to. So, Ryan, thanks again for your time. I learned a ton. I got a lot out of this, and I appreciate you taking the time out of your day, your busy day, to speak with me. So thanks so much, man.
Thank you.
Thanks for tuning in to Trial and Medical Error. We hope our discussions have equipped you with actionable insights to lift your clients above the hurdles of medical malpractice litigation. Ready to refer or collaborate on med-mal and catastrophic injury cases? Visit our attorney referral page at pamedmal.com/refer. See you in the next episode.